I know we're gathered together to continue our conversations followed the 9/11 tragedy. And again, I do want to thank Stacy and Candace, there they are, for all their help in getting this going. Today we were, of course, prepared, Professor Herman is here, to talk about constitutional issues related to the attack and the aftermath. In the meantime, we've obviously had another very difficult night. And I did, as you can see, I know we're all hungry for the news, but I did turn off the TV. I think, understandably, we've come together for another purpose, and we'll see the direction that the conversation takes. I really want to thank all of you for being here and coming together to talk and have a learning experience as well. So thank you very much, Professor Herman and Shilby.
Sure, I guess I better stand out so people are going to be able to see and hear. I guess where I would want to start is by asking the first conversation that we had after September 11th. A lot of people were feeling like they weren't really quite ready to talk about legal issues, and given this morning's plane crash and events, the first question that I want to ask you all is, does anybody feel that we've kind of been preempted? What we had planned to talk about today was what Congress has done so far with response to September 11th, some of the Department of Justice actions, and then to talk about what might or might not be unconstitutional, what's been controversial. Is there anything that people want to talk about that's more immediate than that? Anyone want to raise anything, or should we go ahead with the agenda? Let me also introduce our new political figure, who's always at 12 meetings at any given time. I'm Susan Herman, as the lead said. This is David Yaski, our newly elected city council member, who therefore can talk freely about politics.
Or maybe less so.
You're about to be able to talk about that. So what we had thought is first describing a little bit about what Congress has actually done, and then maybe having some conversation about particular topics depending on what people are interested in. In the blue handouts, which are over there someplace. The top page is a printout from the Library of Congress website, and this is congressional action since September 11th. You notice at the top there's the website if you want any more information about any of these things. You can back down and click on any particular provision or bill that you want. And then at the bottom, in the bottom left-hand corner, it says page 1 of 9. You notice that Congress has been doing a lot of things. The first list here are the things that have actually been signed into law. Then there are pages and pages of other resolutions and other things that have been pending on the floor, among which are the Aviation Security Act, that, as you may be aware, has been a subject of great debate. We thought in terms of the congressional actions, the two on which dates are listed are the two that I think we would want to start by focusing on. First, on September 18th, Congress enacted the authorization for use of military force that you have on the second page, just the back of the first page here. There's the text of the resolution. And the next thing is the USA Patriot Act, of which I've given you various summaries here because you don't want the whole act. The whole act, the USA Patriot Act, you can see what the acronym is for: uniting and strengthening America by providing appropriate tools required to intercept and obstruct terrorism. Somebody spent a long time on that act. This is the USA Patriot Act. Okay, that's what it is. Hardly anybody has read the whole thing. And even if you read the whole thing, you wouldn't know what it says, because I will literally open this to a page at random. And what it says is, subparagraph E of section 5312(2) of Title 31 is amended to read as follows. Delete the word, insert the, you read this and you haven't read it because you have to do a treasure hunt back through the entire federal code to see what's being amended, and then looking around at the impact that this has had on the law. For that reason, most reporters haven't really been able to do this. They haven't been able to read the whole act and absorb what it is overall. Some reporters have done a good job on some sections following through. So what I've given you is I've given you a printout from the ACLU website, which describes some of the controversial features of the act, as opposed to the whole thing. Because the ACLU is among the people who have done an analysis of the act and tried to follow down the treasure hunt. Usually, as I was telling Candace, when I distribute materials for class, I try to distribute things that are neutral or both sides, but this is what there is, and in all likelihood, this is also the source of most of the reporter's information. So you also have the website there if you want to track down any additional details. Why don't we jump in? You want to start talking about the War Powers Resolution? The War Use of Force Act? And then we can talk about that, and then we'll go on to the USA Patriot Act, which one of the chief issues that I think we want to focus on is the ways in which the new act expands all sorts of surveillance powers, wiretapping, internet surveillance, financial and student records, access to information of all sorts. So, do you want to start by talking about the September 18th?
Sure. It's worth taking a look at kind of exactly what it is that Congress passed and authorized. It's the second page of the blue handout. And I'm in kind of looking through the materials, both this and the summary of the USA Patriot Act, I was struck by how similar the kind of issues are in both the macro context of War Powers Act and what does the Constitution say about when we go to war, and the smaller kind of context of what does the Constitution say about when the police can look at your private files. And it's really about how much does the executive branch have to go and explain itself to a third party, a neutral third party, ahead of time. The third party, in this case, being Congress, and kind of if you look at what Congress passed here, they said that the President is authorized to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored such organizations and persons. And if you think about how kind of that compares to a traditional declaration of war, it seems to me that it's much, it's just much more kind of open-ended. So, hypothetically, the President decides that Iraq was responsible for the terrorist attacks. I think this authorizes the President to invade Iraq. The President decides that certain, groups within Algeria were responsible, aided the terrorist attack. I think this authorized the President to invade Algeria and go after these, in search of these groups. And it seems, and what's kind of missing, it seems to me, is the requirement that before the President commits us to a war, that the President has to go out and lay out his bill of particulars against against the offending country. Now, it may be that kind of this is a more hypothetical than a real danger, that, if before the President really, in practice, right, before the President if the President really was going to raid Iraq, he would go on TV with a speech and say, here's why I'm doing it, and without doing so, even though he's not required under this resolution to do so, the judgment would be that to avoid a political problem for himself, he's got to do that. But I still think kind of there's a role. I mean, if we were confident that what was the politically feasible thing to do was always, the best thing to do, you wouldn't need the Constitution at all. I still think there's a role for constitutional requirements to make sure that that process is respected. And the value of requiring the President to make a public case like that isn't just that you want to make sure that there's a real reason there. I think it's also to make sure, in other words, that you don't want the President to make a mistake and invade the wrong country. I think there's also, a kind of benefit to having the public fully informed. First of all, it results, I think we've learned one thing, right? We've learned that for the country to commit to be successful militarily, there has to be broad public support. You can't do it with the president kind of acting too much unilaterally, and I think it's a mistake that, we want to help presidents avoid making mistakes themselves by thinking that they can go forward unilaterally. It also may be the case, it seems to me that in this case, it may be that there are wrongdoers that the president's not going to be anxious to go after. What if it turns out that parts of the Saudi government, who knows? I'm kind of making this up, right? I don't know anything that anybody doesn't. I don't know anything that you don't know if from reading the papers, but from reading the newspapers, it seems to me that there's plenty of reason I think it's plausible that there are friends of the Al-Qaeda network in more government, in other places than Afghanistan. And I think maybe we ought to have a kind of full and fully informed public debate about just what sort of a response that requires and what the foreign policy implications that has. And having a requirement that before you use force, the president has to go out and make his case to the public, to the Congress, public representative, in a specific way, I think helps further that. So, I'm kind of troubled by this, the breadth and the open-endedness of this authorization here. Just to anticipate kind of the other side, I suppose the other side is, well, wait, we're fighting kind of a shadowy, devious terror network, and the president has to have a free, flexible hand to respond. And if we're fighting with one hand tied behind our back, if we're going to require the president to go through all kinds of procedural niceties before he uses force, certainly Al-Qaeda has no such requirements on it, and why do we want to impose that on ourselves? And I kind of see the force of that argument. It is, you say, well, wait, it's not realistic. When Congress passed this on September 18th, I guess, a week after the 11th, they didn't know enough to know who was responsible and what the right course of action was, and the president had to be able to do whatever was necessary. And I guess I would say that, might it prevent some military actions that would be efficient, effective, get the job that needs to be done, if the president had to go and make the public case? Maybe it would, but it would also prevent other, ill-advised, wasteful in terms of resources and more important lives, actions. And, my sense is that on balance, we'd be better off. So that's kind of my introduction to the problem.
Okay, since David sort of introduced this by talking about essentially the politics, maybe I'll say a few words about whether or not there's any likelihood of this being held unconstitutional, to which the answer is no.
Right.
First of all, what the Constitution does with respect to the war powers is it splits the war powers. So Congress is given the power to declare war, to raise and support troops, and to support armies and navies, all the funding kinds of things. On the other hand, the president is the commander-in-chief. There have been, before this, for example, in President Bush, the senior war in the Gulf, there were a lot of issues about whether presidents can send troops as commander-in-chief and the, quote, sole organ of foreign affairs, whether a president can commit troops without authorization by Congress at all. We don't have that problem because Congress essentially wrote the president, as David described, a blank check, saying go ahead and use troops any way you want. The courts have not been involved, to speak of, in issues about the war powers. The Supreme Court has almost never decided a case about this. Partially, think of how difficult it would be to have a case that would actually come up that would be justiciable for a court to hear. But the courts haven't really wanted to be involved in mediating disputes between Congress and the president about what can be done. And another thing that's true is what David was describing is essentially the problem that one might have with this resolution, if you look at it, is it sure gives a lot of power to the president. and it seems to read out Congress. If Congress at any point, under the War Powers Resolution, which they mentioned in the last paragraph, they reserve the right to, by joint resolution, order the President to bring back the troops under the War Powers Resolution itself. So presumably they could do that. But on the other hand, it's not clear how much they're in the loop about exactly what's happening in Afghanistan and how many reports they're getting and whether the decision about what to do about Iraq or Saudi Arabia would come to them first. Because presidents, certainly since Richard Nixon, have been claiming the right to make that decision essentially on their own. Now, one thing that is true in terms of whether Congress can give away, to the extent that these might be Congress's powers to declare war, if there's any issue as to whether or not that's constitutional for Congress to give what portion of the war powers or its own powers to the President, what you need to know, what you may remember from constitutional law, many of you, is that during the 1930s, the Supreme Court decided a couple of cases saying that it's unconstitutional for Congress to delegate too many policy decisions to the executive branch. But since the 1930s, they have totally backed off of that. The, quote, non-delegation doctrine is pretty dead. Last year, there was a case involving the Environmental Protection Agency, where it was argued to the court that the Congress had delegated too many decisions to the Environmental Protection Agency, and the court said, no, we don't want to look at that. We don't want to supervise whether or not Congress is giving away too many powers. So even if it should be Congress's power to declare war, as David said, and even if the idea is that there should be a check, even if the idea of the Constitution is that there was supposed to have been a check on the President's decision to commit troops overseas and do something that, if not called a war by Congress, is certainly the equivalent of a war, the courts don't supervise. That's not a line that they police. They're not going to say to Congress, you can't give away that power, which means that this is not a constitutional question. Congress avoided the constitutional question that might have come up by doing this, by giving the President a blank check. So what this is now is a political question. And I certainly want to share David's observation. As we were talking about what we might talk about today, the theme that kept coming up is the incredible centralization of power in the presidency. You think about Congress being left out of the loop here, they're leaving themselves out. They're saying, go ahead. And maybe at some point, if the President wasn't reporting to them enough, they would get upset and ask the President for more reports. The courts are totally out of the loop here. They're irrelevant. And we're out of the loop. There's not even press over there. All we're hearing about what's happening in Afghanistan is what the administration is releasing. So we have no independent source of information and no check. As David's describing, it's a political problem, but as the Supreme Court has set things up, it is not a constitutional problem.
Yeah, no, I mean, look, no question, I'd agree with the point that no court in the country is going to declare the military action in Afghanistan unconstitutional on grounds that this is not a proper declaration of war. And they wouldn't even get to the question, is it a proper declaration of war? They'd say this is a political question. The few times that lower courts did face the question of the Vietnam War, is this a constitutional war or not, for which could arise in a whole bunch of different reasons. People trying to say, well, I'm not obligated to go to war. I was allowed to not respond to my draft notice because it's an unconstitutional war, being the most common. Courts, uniformly said this is not for us to decide. It's a political question. Now, that being said, I still think it is a legitimately constitutional issue, and not not just a. I would resist saying it's merely a kind of political issue, unless political and constitutional are close to synonymous. I mean, I think it's a question about that we do have to take seriously. Was the Constitution want to see that? How does the Constitution want to see the President and the Congress act here, even if no court in the country is going to force them to do it? I still think it's a kind of valid and appropriate question. And the one other observation I make is to say, maybe sort of restating what I said before, that I think the people that wrote the Constitution would have recognized, would uniformly have regarded this as illegitimate. In other words, I mean, when the Constitution was written, there's tremendous debate about whether the federal government should even have its own army, right? Well, practically half the people that wrote it didn't think the federal government had any business having an army. And even to the extent that they were willing to let the federal government have an army, they very much were afraid of letting the president have unilateral control over that army. They were very much afraid that, and you read the Federalist Papers, they talk about what brought down, the Greek Empire. It was military adventurism. What brought down the Romans? It was military, empire seeking. They didn't want the president wasting treasure and lives in needless adventurism. Now, obviously, an attack on the homeland isn't needless adventurism, but I think I'm comfortable saying that people that 200 years ago, this level of discretion of the president would have been seen as illegitimate. Now, that's not necessarily to say it's illegitimate now. Maybe it's a way of saying kind of how much the country's changed, how much the Constitution's changed, but I do want to make that claim.
I think maybe the best thing to do is to allow for people's remarks or questions or whatever you have on war powers before we move to another subject. What do you think?
Yeah.
Anybody? Comments or questions on the war powers, on the authorization of force, the constitutional issue, and before we move on to the other acts? Nothing now, you're all stunned. Aggregation of power. Well, okay, should we go on to talk about the USA Patriot Act then, and the additional provisions here?
Well, I'd just say kind of one way to frame the question, just to think for yourselves about, is do you think, would you have had a problem with the president acting without something like this being passed? In other words, the president, Congress doesn't pass anything. The president on his own starts to bomb Afghanistan and sends a bunch of soldiers over there, and and let's fast forward 2 months, and let's say there are 1,500 soldiers actually on the ground fighting with the Northern Alliance. Does that trouble you? And I guess I'd say if it does, then I think you ought to be troubled just as much by this, because whatever purposes would be served by having Congress authorize it in the first place, I'm not really sure we're served by this. So that maybe is a sharper way.
I mean,
We have first question, second.
so far what has gone on militarily is different in degree, but not that much different in type than what Clinton and Bush Sr. had done. Sort of whenever they regarded there having been an attack, like on the USS Cole, Clinton sent in and bombed. I mean, certainly this is a higher degree, but we have yet to officially have ground troops fighting a war, and so I mean, we all anticipate obviously that this is going to be a much different thing, and we have from day one before anything had happened. But I mean, is so far where the story is right now, is anything legally that much different than what had been going on anyway?
Well, I guess if you take my, legally different, I get the kind of glib, easy answer would be Susan's answer, no different, because you can go ahead, you can fight World War II and with this, so you can certainly do anything short of that. I think if you do take seriously the notion that there has to be some check on presidential war making, then you're confronted with the line drawing problem of at what point has a president launched a war, as opposed to, bombing. If the U.S. had bombed Saddam Hussein's, nuclear weapons plant, and it was a one-day event,
Right.
and you say, well, that's not a war, and I'd be ready to say that doesn't count as a war. At what point does it become one? I agree. You've got that kind of line.
My point in making is that this should have been probably something that I mean, obviously people weren't up in arms or weren't thinking about this to the same degree, but should have been something that was addressed when those sort of actions were going on. And now, certainly there's the political will. People are much more accepting and just say, I don't want to deal with it, take care of it. And certainly politicians in Congress are thinking, I think, the same thing.
Well, let me, 2 points. First, in terms of the history of this, as was pointed out for people in the back who couldn't hear, President Bush sending over troops to Afghanistan may be different in level, you were saying, but not necessarily in type of thing to do, from what a number of presidents, including Clinton, including Bush Sr., including perhaps President Nixon, have done in the past. So there is a history of presidents committing troops. Let me say that my glib answer about what the Constitution says is not my own glib answer of constitutional interpretation. It's my glib characterization of what the Supreme Court would almost certainly say if a case were to come before them. And that's because of, as I said, how they've set things up. If they don't believe in having a non-delegation doctrine where they're going to say to Congress, you can't give that power away. As David says, the framers of the Constitution split the war powers, and it was for a good reason. They wanted Congress and the President to have some level of agreement before you could send the troops. As we were saying, in this resolution is some level of agreement. David is saying it's, in some ways, it's such a blank check that Congress hasn't really agreed, except to say, go ahead, you're the quarterback, do whatever you want, and we're not going to second guess you, at least for a while. So, I think you're right that constitutional issues have been raised. There were people who raised constitutional questions when earlier presidents sent the troops in the absence of an authorization like this. There's a case that I use in my constitutional law class where Representative Ron Dellums challenged President Bush Sr. When he committed all those troops. There were hundreds of thousands of troops in the Persian Gulf before Congress authorized the use of force. And there was very much a constitutional question of was that permissible. One of the questions about constitutional interpretation, if you're looking at the war powers and saying, do we need Congress to play more of a role than this, is to what extent does the meaning of the Constitution change depending on what previous presidents have done? Does history really put a gloss on constitutional interpretation? Or can we now go back, should we now go back, maybe David's point, and say, well, we don't really care what other presidents have done. Maybe they were acting unconstitutionally too. Your point, well, why didn't we figure that out before? And I think part of the answer is it's hard for the courts to get a piece of this. It's hard for them to figure out.
Well, I was just going to ask how, whether you think that in the function of checks and balances, at least drawing on the last decade or so, has effectively moved to international law. Because it seems to me that the administration certainly did take steps, both politically and legally, to comply with certain principles of international law, and it also seems that politically that has become, since the first Bush, the Persian Gulf War, and also the military actions that Clinton engaged in also were very, very heavily mediated by the principle of allies' participation and so forth. And there really was no effective, well, no, actually there was debate in Congress in the Persian Gulf, but not with regard, I think, to...
A little after the fact.
A little after the fact. But I just would ask for your comment on that.
Well, yeah, I think that's a great question. It also sort of ties this together with what Nathaniel Berman and Sam Marumba were discussing 2 weeks ago. There was, during the Persian Gulf War, the Bush Sr. Gulf War, there was a lot of discussion. There were a number of people writing articles that I read at the time talking about whether Congress had essentially delegated its power to declare war to the UN by signing on to treaties. Thomas Frank wrote an article called "Declare War, Congress Can't." And part of the argument was whether by joining these international alliances, as you're suggesting, we had so changed the balance of our domestic power that Congress really had kind of written itself out by signing on to international accords.
No, I mean, I think that's your perception is absolutely on target. That's kind of happened to some degree. I mean, that's Somalia. If it was going to come in Clinton, I guess it would have been Somalia, and that was pursuant to UN, authorization. Gulf War, much the same. By the time Serbia, I guess you're right. Maybe more. Maybe that's where we're come up, even more pointedly. And so it has, I guess, that doesn't, and I guess that's a tough question, whether that lessens my discomfort, whether I'm satisfied with that as an alternative to our own homegrown processes. That's.
Well, I also think that doesn't really answer the question of who decides when we go international.
No, that's right. It doesn't at all.
Whether it includes Congress or just the President. And the Supreme Court, again, in a number of cases, has described the President as, quote, the sole organ of foreign affairs. That perception is not considered to apply perhaps totally as much to the war powers as to diplomacy powers. But the other thing that you see in terms of the aggregation of powers in the executive branch going on here is that the President certainly is doing all this diplomacy. There's all sorts of foreign affairs work being done all over the world that, who knows how much Congress knows about it, and we certainly don't know a lot about what's happening. A lot of it is sort of under the table. I think that's one thing that's happening. Anything else on the war powers? Okay, then let's move on to the USA Patriot Act. The summary that I've given you, this one from the ACLU website, gives you a sort of little executive summary of some of the different types of provisions. What we won't be talking about are the immigration provisions. We're going to leave that for Professor Kaplow and whoever else next semester. The wiretapping and intelligence surveillance provisions, I guess we want to talk about some, and some of these other privacy provisions. One of the main things that the USA Patriot Act does, again, in terms of aggregating more power in the executive branch, is it expands the power of the FBI and other federal agencies to investigate in many different areas. Some of the new powers are specifically related to terrorism, some are not. Some are just a general expansion of powers to investigate in criminal cases. And some of these suggestions have been around for a while. Some of this is the Department of Justice wish list. And as David was saying before, in this area too, what's happening is that Congress is giving more and more power to the executive agencies, and they're cutting back on the power of the courts to supervise. Okay, starting with wiretapping and electronic surveillance. What you need to know a little bit for background here, just very generally, this is an enormously complex act, but I'll just give you a few examples of some of the kinds of things that are going on. Before this act, there were two different federal acts that governed electronic surveillance. One was enacted in 1968. It's part of the Omnibus Safe Streets and Crime Control Act, and this is a sort of Nixon-era statute. Title III, as it's called, provides for a whole lot of procedures to govern electronic surveillance. The basic idea of Title III was to try to apply usual Fourth Amendment requirements about how searches and seizures have to be reasonable to electronic surveillance. So the basic idea is that if the Department of Justice or any other federal agency wanted to do a wiretap or some form of electronic surveillance as part of a criminal investigation, they would have to go to a magistrate, a neutral and detached magistrate, and get a warrant or court order by convincing the magistrate that they had probable cause. And then there were some attempts, for those of you who know about the Fourth Amendment, to meet the particularity requirement. You had to say just what it was. Fourth Amendment says you have to be particular about the place to be searched and the person or thing to be seized. This was always a little awkward about electronic surveillance, because if you're listening to an entire conversation with the idea that maybe you'll hear somebody make a terrorist plan, it's very difficult to limit what you listen to. You know, do you listen to the whole conversation? Do you listen to every conversation the suspect has, your target? Do you shut off the phone if the person says, "Happy birthday, Grandma"? You know, what do? You know, how do you do that particularity requirement? That was Title III. Title III is essentially trying to do electronic surveillance according to a Fourth Amendment model. In 1978, Congress enacted a different provision that governs surveillance, including electronic surveillance. It's called the Foreign Intelligence Surveillance Act. And that act had a kind of a different thrust. Instead of being about gathering information that would presumably be used as evidence in a criminal case, and therefore people were worried about whether or not the gathering of the evidence complied with the Fourth Amendment, the Foreign Intelligence Surveillance Act was more about gathering information. It's less a Department of Justice Act and more a CIA Act. Most of the Foreign Intelligence Surveillance Act, if you read it, and you can, it's Title 50 of the U.S. Code, sections 1801 and following. Most of what that act does is it provides that for surveillance against people other than what the act calls U.S. persons. It's about surveillance of foreign people, entities, organizations, and the whole idea is just to find out what they're doing. It's a kind of CIA act. Now, the fact that there were these two different tracks, there's Title III, which is if you want to do surveillance of a U.S. person or anyone else for a criminal investigation, you have to meet the kinds of Fourth Amendment requirements. You have to go to a judge. There's judicial review and judicial supervision. While on the other hand, in the Foreign Intelligence Surveillance Act, there's a secret court that's put together. And the secret court looks at applications, but the standard that has to be met before they grant an order to allow surveillance under the Foreign Intelligence Surveillance Act is much, much lower. It's not probable cause. It's just, the whole idea was it was relevant to an inquiry. It was all that has to happen, and all that has to happen under the new act is that the Attorney General has to certify to the court, this is relevant, we need this information for foreign intelligence, and at that point the judge must issue the warrant. So you don't have an independent judge deciding whether or not there's probable cause. You have your judge essentially rubber stamping once the executive agency in charge has certified that this is surveillance that will be relevant and useful to an investigation for foreign surveillance purposes as opposed to criminal purposes. Now, the foreign intelligence surveillance warrants, because they're much easier to obtain than the Title III warrants, have sort of outpaced the other warrants. So in the years between 1996 and 2000, there were 4,275 warrants issued for surveillance under the Foreign Intelligence Surveillance Act. And you want to know how many denied? 0. Okay, there's virtually no standard. Once somebody asks a judge for one of these warrants, that's pretty much it. Okay, so there are these two different paths. The first thing that Congress did to try to expand surveillance authority, and they did this within about 48 hours of September 11th, they first enacted what's called the Counterterrorism Act of 2001, I guess. And what was a little odd about that was they started expanding the powers under Title III, the regular crime electronic surveillance statute, to expand a little bit what can be done if what you're looking for is terrorist activity rather than other criminal activity. But in the USA Patriot idea, they had a different act. They had a different idea. So instead of working with Title III, they're essentially working off the Foreign Intelligence Surveillance Act, and they're expanding the surveillance powers also to U.S. persons and in a number of other areas. I'll give you a couple of examples of what the Act does. The Foreign Intelligence Surveillance Act used to say that this was only for foreign intelligence surveillance, and that what the Department of Justice or CIA, whoever had to certify was that their primary purpose was to do intelligence gathering and not criminal investigation. Under the new expansion, under the USA Patriot Act, even if their primary purpose is criminal investigation, and it's only a small, subordinate purpose to do intelligence gathering, they can still use those reduced procedures of the Foreign Intelligence Surveillance Act. A judge has to grant one of these orders that they request. Again, as long as the Attorney General is certifying that what they're trying to do is gather intelligence information under the Foreign Intelligence Surveillance Act. One of the things that's also been noted is that among the authority that's given, there used to be authority that the government had to get pen registers. You know what that is? That's a list of the telephone numbers that you call. And under Title III, you could get a pen register. And you didn't really have to make a showing. You didn't have to have probable cause. You just had to show that you wanted the information because it was, quote, relevant to what kind of inquiry? Relevant to an ongoing criminal investigation. Okay, this provision has now been expanded to apply not only to pen registers, but to the internet, to email. So now what the government can do is they can get a track and trace order to see who you're sending emails to and who you're getting emails from. Now, as some of you may know who are more computer literate than I am, the Act refers to dialing, routing, and signaling information that the government can collect and obtain. They don't have a definition of those terms. But what people generally understand this as meaning is that the email address and the email, your content of what you're saying, travel together. What the Department of Justice says is, it's all right, we'll separate the two. We're not going to look at the contents of the email. We're only going to look at the addresses. Because apparently, that's the only way they can do it, to gather the list of who you're emailing and who you're getting emails from. Evidently, the new act also means that the government can keep track of what websites you're visiting. And this, again, it's beyond me in terms of technology, of whether that had to be or how it happens. But people looking at the act have interpreted the act to mean that the government can keep track of what websites you're visiting. And this, again, is not on any sort of probable cause standard. It's just the Department of Justice has certified that this is relevant and that it might be related to some sort of foreign intelligence. A couple of the concerns, a couple of the things that are controversial about this is, first of all, the whole idea of looking at the content or the website as opposed to just the address. Second of all, there used to be a special provision under Title III that provided for what's called a roving wiretap. Under the sort of Fourth Amendment model, if you have to say just where you want to search, if you get a search warrant to search a house, you have to say, this is what I'm searching for a stolen car. And then you're allowed to look all the places where a stolen car might be, like in the garage, but not in the medicine cabinet. Here, under the roving wiretap, under Title III, you would say to the court, here's the phone that I want to tap, and the court would say, all right. Title III was then expanded to say, well, you can also get a roving wiretap, and you can tap this person, no matter what phone they're using. Under Title III, you had to have probable cause to get that, and there was continuing judicial supervision. The roving wiretap authority has now been extended to also apply under the Foreign Intelligence Surveillance Act, which means that without probable cause, you can go to this special court, this special division, and you can tell them that you want to keep track of the conversations of a particular person because you believe it's going to be relevant to an ongoing inquiry and it might have something to do with intelligence gathering. And the court then must issue the order, and the order allows you to tap any phone that that person uses or any internet terminal that the person uses. It used to be that the law required as one of the limitations on a roving wiretap that when the particular target stopped using that phone, or in this case also internet terminal, you had to stop tapping, you had to stop listening. Under the new law, there's no such requirement, there's no such limitation. Now again, what's controversial about this is in addition to, you think about the telephone model, if a suspect, a target, somebody who the Department of Justice believes, again, probable cause not necessary, but they're suspecting that person and they want to tap their phones, if that person comes to your house and uses your phone, they can continue to tap your phone. So the authority that Attorney General Ashcroft was talking about, he described it as, we're just getting in the modern age, this is just to mean that we can tap somebody's cell phone if they're taking their cell phone with them. Well, they already actually have the authority to do that. And this really expands that authority considerably in terms of increasing the range of telephones that can be tapped. Another example that's given that evidently under the language of the Act would be permissible is if somebody who's a suspect under this goes to the library to use a computer terminal there, a tap could continue to be, there could continue to be a track and trace order on the computer terminal in the library because that person had used it. And the only limitation that Congress imposed was they said that there actually has to be a showing that the target has used or is using, or is about to use, if you can figure that out, this particular form of technology. That's it. Once they show that, there's again no continuing judicial supervision. In addition, a couple of these provisions, well, most of them really, you can go to any judge in the country to get authorization for this, and then you can use your warrants anywhere in the country, so it allows considerably for forum shopping. It allows, I won't go into any more details, I think that's enough examples to give you the idea. It just tremendously increases the range of electronic surveillance that can be done and minimizes the judicial supervision. These provisions do not only apply to terrorism, they apply to any criminal investigation. They also are subject to a sunset provision and will expire on December 31st, 2005, unless Congress decides otherwise. Okay, so that's essentially what Congress has done, which if anybody has any questions, this is just to kind of give you examples. I know it's a lot of detail to follow pretty quickly. And you may have also heard that the Department of Justice, Attorney General Ashcroft, this is a regulation, this is not something Congress has done, has just announced that one of the additional powers that he's going to be using is to wiretap conversations between inmates and their lawyers. So if somebody's in prison or jail and has a conversation with their lawyer, Attorney General Ashcroft has said that he's going to be wiretapping this lawyer.
Could you just say that these provisions apply to any criminal investigation, not just terrorism?
Yes, any criminal investigation, not just terrorism. Right. So, yeah.
How is an ongoing criminal investigation? I mean, does that mean that what has to be ongoing in order for it to be an ongoing?
What has to be ongoing is a pretty low standard.
I mean, is that like today we decided that this guy might be a criminal, now the investigation is ongoing?
Yeah, it's on as opposed to past. But if you look at the figures, 4,275 foreign intelligence surveillance orders granted, none refused. It's a very broad power, and the whole point of the Act, consistent with what David said before, Congress is conferring the power on the Department of Justice mostly, but also to the CIA, and maybe David's going to want to talk a little about the agencies involved. And the judiciary is being kind of more and more left out. There's less for them to do. There are still court order requirements and warrant requirements, but because there's no particular standard provided, it's just if the Attorney General certifies in a number of these provisions, the language says the court must issue the warrant. So, yeah, please.
The wiretapping conversations of a prisoner with his lawyer, is that what they talked about last week on the news, where they have to give notice to one or both parties that they're taking the conversation could be different than a regular wiretap? Or is saying that above and beyond what they discussed?
I think it's above and beyond. I think it's just, I just was actually reading a statement this morning from the president of the ABA expressing grave concern about the constitutionality of that provision. Most of the other provisions that I just described to you about electronic surveillance and expanding the powers there, it's not clear whether or not the Supreme Court would find any of that unconstitutional. The Supreme Court never looked at Title III, the crime control one, to decide whether it was constitutional, although they did have a few cases that they decided that seemed to assume that. They have never looked at the constitutionality of the Foreign Intelligence Surveillance Act. Partially, it all happens under the table, the warrants are never denied, and people often don't know that that they were ever being wiretapped. Under Title III, you can tell if you're being prosecuted and the evidence turns up being used against you in court, then you know there was a wiretap, so you can challenge how it was done. Under the Foreign Intelligence Surveillance Act, however, because the prosecution is not an assumption, probably most of the people who are attacked never know, and so there's never been a challenge. The Supreme Court has never ruled on these roving wiretaps. They've never ruled on a lot of this, so it's just not clear how much of that is unconstitutional. Joanna?
Did Ashcroft give any justification for that?
Well, what do you think the justification is? I mean, they want to find out as much as they can. It's the basic justification.
Right, but beyond that, I mean, he didn't talk about this.
I didn't see it. Did anybody see any particular justification that Ashcroft gave down?
Oh, I was wondering how he's going to try to get around the old attorney-client privilege with that one.
Yeah, that to me is the greatest problem in terms of risk of unconstitutionality that I've seen so far. And it's not really with what Congress has done, but with what the Attorney General has done. I think it's a problem under the attorney-client privilege to do that.
Is there a distinction being made about the admissibility of the tap and its admissibility ultimately in the prosecution?
Yeah, I think they're not worrying about admissibility.
As privilege, it only arises as to in terms of whether it's admissible. In terms of confidentiality and lawyer-client relationship, that's a different thing. Right? Privilege would only come into play if somebody sought to admit it.
I think that's a great argument because, again, if you think about the two different tracks that I was talking about, there's like the Title III, we're doing a criminal investigation, we want to gather evidence that's going to be constitutionally obtained so it can be admissible in a criminal prosecution. That's one thing, and that's what Carol is describing. If the Attorney General thinks he's going to use evidence in a criminal prosecution that was obtained in violation of the attorney-client privilege, that's a big problem. On the other hand, what they're doing is just saying, we're finding out information. We're hoping to prevent future actions. Again, we don't care whether or not we're ever going to be able to use this evidence. We're just obtaining it. That's a different matter. And the constitutional bars are less significant.
Yes, under the old law, if the police made an unconstitutional search, but it was in good faith, but it turned out to be unconstitutional, and during their unconstitutional search, they found evidence of terrorist activity. Under the old law, would that evidence of terrorist activity have to be thrown out?
Okay, it depends what you mean by thrown out. Again, if what they're doing is using it as a basis for action to prevent something from happening, no problem. The exclusionary rule only becomes relevant where you have evidence you want to use in a criminal proceeding. Do you want to comment on any of the agency things involved here?
Well, I mean, I think one of the, what this really does kind of throw into relief is the difference between the goal of law enforcement being to prevent something from happening out, to gather information that then they can use to, go out and protect somebody, as opposed to investigating a crime. And you kind of think about it, the trade-offs differently, I suppose, depending on what the purpose is. And as the purpose becomes more and more prevention, I guess it gets easier to, give greater and greater latitude to law enforcement.
To put something else on the table, too, I think part of this two-track idea is one reason why President Bush wanted to create the Tom Ridge Office of Homeland Security, because he wanted something to supervise both of the tracks, to kind of be on top there, to kind of know what both of the hands were doing, which is not so easy.
It seems like one thing that's going on here in all of these amendments is that you have these two different tracks, but over in the security track, prevention track, it seems like expanding when you can use those sort of methods. On the other side, eliminating a lot of the restrictions on the protections against doing just that sort of thing, so almost like you're sort of erasing the division between the two.
Yeah, a lot of there's more power being
like
conferred and fewer limitations, far fewer checks. And among the checks that we don't have, again, since we've been talking about Attorney General Ashcroft, the other thing that the Department of Justice has done, of course, is they have arrested and detained over 1,000 people. And we don't know who or why. And the freedom of information issues here are clearly also, Congress has also enacted a number of pieces of legislation cutting back on information that's available on governmental websites. And so that's another big issue. We just can't tell how many people are being detained as material witnesses or for illegal immigration issues.
I think your point is a really good one, that if you kind of look at this, from the constitutional perspective, or how is it affecting constitutional, what's developed certainly since 1945 or whatever in the constitutional world is a very clear difference between foreign affairs, security concerns, national security, and domestic. And in some ways, it makes, going to go back to when I started out with talking about the war powers and limitations on the president's ability to make war, you might say, when you think about it that way, then my kind of desire for checks and balances there seems all the odder, right? Because in the domestic sphere, we've largely, as Professor Herman points out, abandoned notions of limits on Congress's ability to delegate, and we've accepted Congress writing blank checks even in the domestic regulation sphere. And you combine that with the fact that the courts have always been willing to give much greater latitude to the president in foreign affairs than in domestic. Say, well, we're willing to let the president have a blank check in domestic affairs, all the more so you'd think we'd be willing to do so in the foreign affairs scheme. And what I think a lot of what is going on here is kind of looking at even more of what the government does in the context of this foreign affairs world where the president is granted great latitude.
And again, under the Freedom of Information Act, there's a national security exception. So, in terms of the possible check on government, not just being the other branches of government, but being the informed public, most of what's going on here we can't find out, either because it's directly within the exception to the Freedom of Information Act. There are also, I gather from David Vladeck, proposals going on to amend the Freedom of Information Act to take even more information off the table.
Yeah, it's my understanding that these rules are ostensibly for increasing security in our country. And my question is, how is it, is there any way to prove, or is there any proof that these kind of invasions of privacy in any way help increase security?
Okay. Is there proof that these kinds of invasions of privacy increase security? Of course not. There's no way to tell. The only body in a position to tell, some of these provisions, there are congressional oversight mechanisms. So the only thing that can happen here is that the various departments are supposed to be reporting to Congress under some of these provisions what they've been doing. And then Congress presumably will be in a position to evaluate that. We're not. And we can't say yes, it's worth it, or no, it's not worth it. For one thing, given that a lot of the foreign intelligence surveillance is aimed at prevention, it's very difficult to know. Do you remember one of the last times that we were told that there was the national emergency, that there was going to be a major terrorist event, and there wasn't? And what people said was, good, we prevented it. But, how do we know whether it was prevented or it wasn't going to happen? It's very difficult to evaluate.
Yeah, and that just kind of, to me, points up, the other dynamic that I think one has to be watchful for is greater discretionary powers may seem perfectly appropriate in a period of crisis, but of course, once it's a real ratchet effect. Once given, they don't go back. And a year from now, when the security need may seem less pressing, the president's still going to have all the powers granted under this act, forever.
But some of the electronic surveillance powers, some of those sunset after 4 years, but others of the powers don't. The search and seizure powers don't. I'm not sure offhand about some of the informational privacy issues.
Assuming that these different provisions are unconstitutional and the evidence collected under them wouldn't be admissible in court.
If they were unconstitutional, not likely. What David is saying about I was just actually reading something this morning that was summarizing how the Supreme Court has acted in response to constitutional claims at times of war or other perceived national emergencies. And you look at their track record. In the Civil War, ex parte McArdle says they ducked the question of whether or not Congress can suspend habeas corpus. You look at the World War I cases, the Alien and Sedition Act, and the Supreme Court at least starts out by not being so good on the First Amendment. During World War II, there was Korematsu, the case where the court upheld the internment of Japanese Americans, deferring to the executive branch claim that it was necessary for national security. And in virtually all these cases, after the fact, people look back and say, oh, well, that was a mistake. There wasn't really very good evidence that the Japanese Americans were a threat. There's also the McCarthy era, where the Supreme Court regularly deferred to decisions of the executive branch or Congress about what was necessary to contain communism. And then even the Vietnam era war protests. It was, again, the courts kind of went along. The one counterexample that I can think of, actually, which gives me a lot of comfort, is West Virginia versus Barnett, which is a case decided during World War II, where the Supreme Court upheld the right under the First Amendment of children not to salute the flag. And it's a very interesting opinion in terms of a different approach during a time of war. But I think there's no particular reason to think that the current Supreme Court is going to be going through and declaring these provisions unconstitutional. So I think we're not going to get to the point of will the evidence be admissible. Anything now? You want to? Maybe I'll just say a few words about the informational privacy things that this does here. This is on the 4th page of this website, the summary. In terms of financial privacy and student records, the new provisions of the USA Patriot Act give the government far greater access to individual financial information, including credit reports. Also permits the Treasury Department to require financial institutions to monitor individual financial transactions and report to the government a whole variety of things. With respect to student records, you may remember all the information that you had to provide to and that was provided by others to the federal government under the National Education Statistics Act. It used to be that all the information that was provided about students to the federal government was confidential under the Family Education and Something Privacy Act, FERPA, unless there was consent to having that information disclosed. The USA Patriot Act repeals the confidentiality provisions so that now federal agents can get access to all student records in addition to financial information. But among other things, this means that I think something that does appear to have been happening is that they can check the records of people who are foreign, who are not citizens, or people of a particular ethnicity, and nobody will ever know. It's just under the table what they're checking. There are also a lot of other provisions in here. You have the summary, you have the website available. There are new substantive criminal laws providing new definitions about what constitutes terrorism or harboring terrorism, etc. The statute of limitations has been eliminated for all crimes relating to terrorism, and the maximum penalties for many, many of those types of provisions have been upped.
What, if any, cause of action might I have if my phone was tapped, my email was monitored, and they just got me by mistake? Is there any, Korematsu, maybe there was a property claim and they were barred by the statute of limitations, but is there any way that I can say, something was taken from me?
Well, one thing is that you're not likely to ever know, because all these wiretap, again, the only way that the wiretap issues come up generally is that the government seizes evidence and then they prosecute you and they use the evidence against you. If they've been wiretapping you and have come up with no information and never come after you, you're not going to know that they wiretapped you. One of the other provisions of the USA Patriot Act provides that a search warrant can be executed, and the government can go into your house, execute a warrant. They can copy the hard drive off of your computer and not tell you. And that's also a change from previous law. It used to be that after a search warrant was executed, they had to tell you what was taken. And now they don't have to tell you.
So my only chance of challenging this is if for some reason the government goes after me and tries to convict me of something, and maybe I could argue that it should be excluded because it's constitutional.
That's
Other than that, I have no claim for anything being taken from me.
I can't, anybody think of other kinds of claims you could raise?
Can I get a Freedom of Information Act request to find out if this is happening to me?
Not likely. I think a lot of this is going to be under exemptions. I don't think the Freedom of Information Act is going to work. I don't know a lot about the Freedom of Information Act. That's where Professor Yaski's department.
Yeah, but it is. That's an interesting exercise trying to think about how might you formulate a claim that's aimed at saying at least we have a right to know if we're being affected by this or not. Under some form of Bivens claim that says part of the Fourth Amendment is at least knowing what the government is doing.